yesterday, and that ruling will be read by the Honorable Justice.
Thank you, Chief Justice. Shown in the first respondents forms 34B and its public portal show a significantly higher number of votes that was spoiled or rejected. At paragraph 21.21, they also claim that the data and information recorded in forms 34A at the individual polling stations were not accurately and transparently entered into the KIMS kit at the individual polling stations, and specifically that in more than 10,000 polling stations, the data entered in the KIMS kit was not consistent with the information and data from the respective forms 34A. In the petition, therefore, and as a foundation for the application, they seek the following specific orders: an order for scrutiny of the rejected and spoiled votes, an order for scrutiny and audit of all the returns of the presidential election, including but not limited to forms 34A, 34B, and 34C. And 3, an order for scrutiny and audit of the system and technology used by the first respondent in the presidential election, including but not limited to the KIMS kit, the server or servers, the website or portal. At page 3 of the ruling, we have set out in extenso the specific prayers which the applicants seek in the application, and they run up to page 9 of the ruling. We have then summarized the case as made by the petitioners, by the first and second respondents, by the third respondent, and we began the analysis of the case at page 15 of the ruling, where we have set out the law as regards scrutiny, the jurisprudence by the High Court, the Court of Appeal, and this court as regards scrutiny. We have then also gone further to set out the law as regards the right to information under Article 35 of the Constitution, Section 4 of the Access to Information Act, Section 27 of the IEBC Act, and Regulation 15, 16, and 17 of the Elections Technology Regulations 2017. We have applied then the principles in both the decisions of the court and the law to make the following point: that the criteria in our view for determining whether we should grant the orders that are sought by the applicants must take into account both the time that this court has to hear and determine the petition, and to ensure that the orders we shall make are practicable, reasonable, and helpful in reaching a just and fair determination of the petition. We also note that the petitioner's apprehension that the physical forms 34A and 34B, produced in court by the first respondent, and this is their view, may not necessarily contain the results that were electronically transmitted, and therefore the request to access the IBC's system in order to confirm the validity of the information contained therein is a matter to be taken into account. We also take into account the fact that our system of elections is partly electronic by its nature, and therefore the role played by technology in this regard cannot be ignored. In that context, we shall then analyze the prayers in the application in the context of that criteria. With regard to prayer 3 specifically, we note that some of the actions for which access is sought have the potential of compromising the integrity and security of the first respondent's electro-technological system and of individual persons, which, if granted, is likely to compromise the future use of the system. And therefore, in making the orders we're going to make, we have to be aware of the need to protect confidentiality of passwords and usernames, identity of password holders, IP addresses, software running applications, and so on. Prayer 3 also seeks, in general terms, possible security and software integrity issues which would necessitate orders that will protect those security, that software. And therefore, we must grant orders that are timeous and also relevant to the issues in contest. And at the end of the ruling, we shall grant orders of access and supply of information that meet the above criteria, and we are confident that the said information will assist the court reach a fair decision in the petition without jeopardizing or compromising any party's position in the petition. Specifically, we have looked at prayer 3 of the application with regard to saffron identity and security, and there's no contestation to the submission by counsel for the first and third respondents that this is a company, a software company based in France, and not being party to these proceedings, demand that quote-unquote persons and systems related to it should be accessed by the petitioners, in our view, is impractical and may necessarily delay the hearing and termination of the petition. We also looked at prayer 7 of the application, where the applicants seek further orders to file further affidavits arising from the information being obtained from whatever orders we're going to make. We have looked at the time left for hearing the petition, which is less than 4 days, and it's our view that such an order would only but delay the proceedings, and we see no prejudice. We see prejudice if the respondents would not be able to respond to the issues raised therein. And that prayer, therefore, is disallowed. Having so held, and setting the criteria for granting of the orders shall shortly make, one aspect of the petition application requires addressing at this stage. It has been the petitioner's claim in pleadings that during the presidential election, Forms 34A were not captured, stored, and transmitted in the expected timeframe, a claim partly raised in prayer 3G of the application. In that context, we shall shortly make an order that the first respondent shall supply to the petitioner and the third respondent for their scrutiny the scanned and transmitted copies of Forms 34A and 34B. In a nutshell, then, the final orders that we shall make are the following in the context of the criteria that I've just read. It is our view that it is our order that the petitioners, as well as the third respondents, shall be granted a read-only access, which includes copying, if necessary, of the following information. A, information relating to the number of servers in the exclusive possession of the first respondent. B, firewalls without disclosure of the software version. C, operating systems without releasing the software version. D, the password policy. E, the password matrix. F, system user types and levels of access. G, the IBC election technology system redundancy plan, comprising of its business continuity plan and disaster recovery plan. H, certified copies of certificates of penetration tests conducted on the IBC election technology system prior to and during the 2017 presidential election. These will include certified copies of all reports prepared pursuant to Regulation 10 of the Elections Technology Regulations 2017, and shall include certified copies of certificates by professionals prepared pursuant to Regulation 10.2 of the Technology Regulations. I, specific GPRS location of each KIMS kit used during the election for the period between the dates and including 5th August 2017 and 11th August 2017. J, a certified list of all KIMS kits procured but not used and or deployed during the election. K, polling station allocation for each KIMS kit used and or deployed during the election. K, polling station allocation for each KIMS kit used during the presidential election. L, technical partnership agreements for the IEBC technology system, including but not limited to A, list of the technical partners, kind of access they had, and list of APIs for exchange of data with the partners. M, login trail of users and equipments into the IEBC servers. N, login trails of users and equipments into the KIMS database management systems. O, administrative access log into the IEBC public portal between 5th August 2017 to date. P, the information listed in M, N, and O above shall be issued in soft copy to the petitioners and the third respondent. Q, certified copies of the original forms 34A, 34B, 34C, prepared at and obtained from the polling stations by presiding officers and used to generate the final tally of the presidential election, and pursuant to that production, leave is granted for the use of an aid or reading device to assist in distinguishing any fake forms from the genuine ones. R, Form 34As, 34Bs, and 34Cs from all the 40,800 polling stations. This is the language of the application and the language of the press that is in the application. And S, scanned and transmitted copies of all Forms 34A and Forms 34B. Consequent upon the said orders, we hereby make the following further orders. 1, the registrar of this court, assisted by a number of judicial officers and staff, as she may determine, shall supervise access to the certified copies of original Forms 34A and Forms 34B by the petitioners and third respondents at such a venue as she shall determine in consultation with the parties. A report on that exercise and related issues shall be filed by the registrar by Tuesday, 29th August 2017 at 5 p.m. and parties are at liberty to submit on it at the end of the hearing. 2, in the exercise set out in A to P above, priority shall be given to the following. 1, the 292 polling stations as deponed to at paragraph 12 of Norman Magaya's affidavit sworn on 23rd August 2017. 2, the 688 polling stations as deponed to at paragraph 15 of Omar Yusuf Mohammed's affidavit sworn on 24th August 2017. 3, the 14,078 polling stations as deponed at paragraph 70 of Dr. Nyangasi Oduo's affidavit dated 18th August 2017. 3, an ICT officer designated by this court from among its ICT staff and 2 independent IT experts appointed by the court shall supervise access to the technology in paragraph 72 above at such a venue as they may determine in consultation with the parties. A report on that exercise and related issues shall be filed by the said officer and experts by 5 p.m. on Tuesday, 29th August 2017, and parties at liberty to submit on it at the end of the hearing. The parties to the petition are entitled to have a maximum of 2 agents or experts in each of the above exercises. The agent should at all times comply with the directions of the registrar and the ICT officer to ensure expeditious conclusion of the above exercise. There shall be no orders to cost, and it is so ordered. D.K. Maraga, Chief Justice; P.M. Wilu, Deputy Chief Justice; M.K. Ibrahim, Judge of the Court; J.B. Ojwang, Judge of the Court; S.C. Wanjala, Judge of the Court; S.N. Ndongo, Judge of the Court; and I, Lenaola, Judge of the Court. Thank you, Chief Justice.
Thank you, Justice Lenaola. Council Mwite, you seem to be having something?
Yes.
Yes.
My Lord Chief Justice. The first and second respondents will fully comply with the orders that your lordships have given. As we said when we were responding to this application, the Commission has absolutely nothing to hide. And our concerns relating to the integrity and the security have been addressed. So we will fully comply. The only little point I wanted to make at this particular point, one, it will be useful if we can have copies of your lordship's orders immediately so that we can consult with our client and begin to plan the implementation, execution of your lordship's orders. Number two, that we should have liberty. Both parties should have liberty. Once we consult with the Commission, and in particular with their technical people, should there be any need for further directions, we should have liberty to mention the matter before your lordships in the course of the implementation. Thank you.
Yes, Mr. Orengo.
Thank you, my Lord Chief Justice and President of the Court. I fully concur with the remarks of my learned senior, Mr. Paul Mwite. The only thing that I would request, this ruling has an impact on the way we had planned to present the case. And in fact, it enabled us to crystallize our case as a result of this order. So we were going to request for a short adjournment so that we know how we are going to go about implementation of these orders and make some consultations with the first and second respondents particularly.
A short adjournment meaning how long?
I think half an hour, because there's a question of experts and if we can mobilize them.
Very brief.
Yes.
My Lord, thank you for the ruling. We need a copy as soon as possible so that we can give it to the technical team that would assist the third respondent, even comprehend what came from the court. It would appear that simultaneous processes will be going on. So our only request is a copy of the ruling.
Yes.
As we engage here, other persons will be engaging elsewhere. Apart from that, we are ready to proceed.
Very well. A copy of the ruling will be supplied immediately. We will adjourn for another 30 minutes. Make it a little less, Mr. Orengo.
Yes.
We are really pressed. Can we come back at 10? come back at 10 so that you organize and you realize what our order reads. Concerns were raised about the compromise of the security of the data. So the wording is very, very clear. Read only with leave to copy. So that we don't want the issues, somebody saying, look, we can't give you this because it will compromise. We are very, very careful with the wording of the order. So please take minimal time so that you organize yourselves as we go on. We come back at 10 o'clock, but before we leave, there is a ruling we read last night regarding the amicus curiae by the Attorney General. I'm sorry, there was an error on that ruling. What it read is that the Attorney General can submit on all those other points except the impact or the meaning of the authority. Let me read the final order. The application is hereby granted with orders that the question, what was the effect of the jurisprudence initiated by the Court of Appeal in the case of IEBC versus Minor Kiai, how IEBC conducted the presidential election in issue, end of quote, be expunged from the amicus brief. In other words, the Attorney General is only limited, not to, you can submit on all other points, but that point you're not going to submit on.
My Lord Chief Justice, members of the court, I welcome that clarification and I thank you.
Okay. Thank you very much. So come back at 10.